What I need is some help staying on my meds, because I start feeling like I'm doing better sometimes, and then I stop taking them. When I stop taking them, I hear voices, and I can't tell if it's mine or if it's somebody else, or I can't tell.
So, but Mr. Wadsworth, here's the thing.
Yes, ma'am.
And I appreciate what you're saying, and I feel like you are sincere in what you're saying.
Okay.
The problem is you're 51 now, 52?
51. Ma'am.
51.
Fixing to be 52.
And you know you've had these issues.
Yes, ma'am.
You've been given opportunities, and you know I need to be on my meds. And even if I give you a probation, it's only for so long. At some point, you have to stay on your own meds, and you can't require someone else to force you to do that and take a chance with society and the community of you hurting someone else. Honestly, I'm not sure, but I honestly think that you have the worst criminal history I've seen.
I even said that to Mr. Rojas. I said, this is
You have 19 misdemeanor convictions. You have 20 others that were either filed, dismissed because of pleas on the other cases. So technically about 39 misdemeanors, 21 felony convictions, 21. I know, wow, right?
I'm not.
You still have one pending in Indiana. And
Notice what the defense is doing here. They're not denying the criminal history because, frankly, they can't get. They're trying to create a timeline for the judge. Years of trouble, followed by periods of stability when medication and treatment were involved. In sentencing hearings, that's often the only path left. Not arguing innocence, but arguing for mercy. But with 7 additional felonies after 2002, the judge is going to be asking one very difficult question. How many chances are enough?
not that long ago, given a probation, it was revoked. So you were given an opportunity. Mr. Smith?
I've completely stayed out of trouble since then, though. Not one single incident.
Well, you had 2017 an unauthorized use of a vehicle felony. 2018 an obstruction of justice in Pike County.
Yes, ma'am.
2019 an escape. That's the one that's
That was my
pending.
last one.
Hold on.
Oh, I'm sorry.
And then another later in 2019, maintaining a common nuisance of a controlled substance or something like that in Indiana. So the last thing is 2019, which is, in the big scheme of things at your age, not that long ago.
I know, I understand.
Mr. Smith?
Judge, I would point you to his account of probation where he said the part about the baseball bat is not true. A dresser fell on top of it.
I saw that.
He's still not accepting
I
responsibility.
hit him with the cane.
Hold on, don't
I'm
speak
sorry.
over. I let you talk, so don't talk over anyone else,
I'm so
please.
sorry.
I believe probation is absolutely right that jail time and probation has not been a deterrent for him. He's not made probation. We would ask for the 8-year sentence to be sent.
Mr. Wadsworth, again, like I stated before, to Mr. Rojas, the fact that he was able to negotiate for you a cap of 8 years on a second-degree felony with your criminal history, there's part of me today that was considering not even accepting this plea agreement. Because I think with your criminal history, personally, I think it's ridiculous.
I have to understand.
So I'm going to find that you entered your plea of guilty freely and voluntarily. I'm going to find that you entered your plea of guilty. I'm going to find sufficient evidence to find you guilty, and at this time find you guilty of aggravated assault with a deadly weapon. Sentence you to a term of 8 years in the institutional division of the Texas Department of Corrections. There will be an affirmative finding of a deadly weapon. You will receive credit on that sentence for any time that you've been in custody, that the law gives you the right to.
This is the moment the courtroom becomes far more complicated than a typical sentencing hearing. Wadsworth isn't simply describing addiction, he's describing untreated mental illness. Hearing voices, losing his home, and spiraling after a personal crisis. The difficult question for the court is one viewers often debate. When does an explanation become a mitigating factor? And when does public safety have to take priority? Let us know in the comments. Should mental health struggles reduce a sentence when someone has such a lengthy criminal record?
I'll print the exhibits out.
Right here, right here.
They don't X them out because it's set for sentencing, so they still print out the stuff. Well, once it's taken care of, they remove this stuff.
Good grief, I just wrote 2023.
I was writing
2028? Great. At least I'm making us younger, not older.
said I got ready.
What is this? Hers.
I'm gonna take care of it, Mr.
All right, ma'am, good morning. Are you Melissa Taylor?
Yes, ma'am.
And will your client waive the formal reading of the indictment in each case?
So waived.
I'm going to take judicial notice of the court's file. Ms. Taylor was evaluated for competency to stand trial. Dr. Capon did that evaluation. I've received the report dated May 22nd of 2025 with the finding from Dr. Capon that Ms. Taylor is currently competent to stand trial. Is there any other evidence with regard to competency?
Your Honor, I can only say that I've visited with her a couple of times out at the jail and again this morning, and I believe that she's mentally competent.
All right.
I can't say that there's no evidence of mental incompetency because I think that there was at one time the evidence, but there's been none that I've observed that would lead me to think that she's currently mentally incompetent.
All right, and Mr. Nichols?
Nothing to add, Your Honor.
All right, then, based on the report and Mr. Kimler's comments, I am going to find Ms. Taylor currently competent to stand trial. Now, Ms. Taylor, in cause number 24 DCCR 2177, you're charged with second-degree felony offense of assault on a peace officer from October 2nd of 2024, and how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you actually did what they've charged you with?
That would be correct, yes.
All right, and in cause number 24, DCCR 2311, you're charged with the state jail felony offense of credit or debit card abuse from October 2nd of 2024, and how do you plead to that charge?
Guilty.
Again, are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you did what they've charged you with?
Yes, ma'am.
In each of these cases, I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Kimler?
I did.
Do you fully understand them?
Yes, ma'am, I do.
And do you understand, if I follow the agreement that you've made with the district attorney, that you'll be waiving or giving up any right to appeal?
Yes.
And it looks like the agreement that you've reached is for a cap of 5 years in the assault on a peace officer case. And then whatever happens, I guess you're pleading open on the other one as long as I run them
I've made a
concurrently.
recommendation for 12 months on that
Okay,
case, Your
12.
Honor, and the defense had made a recommendation for probation concurrent with the what they.
Okay, so in essence, a cap of 12 months then, with
Yes,
that,
Your Honor, that's fair to say.
Yeah, concurrent.
with everyone's permission,
Yes,
can
sir.
I make that?
So you're 12 months and 5 years.
Well, that's 5 years.
Let's see. Cap. So it would be a cap of 12 months on that state jail.
Your Honor, I do have a support letter that I tendered to the court.
If you'll just get that to the clerk, please. All right. Thank you, ma'am. You can go back with the bailiff. That's exactly when both of y'all do better. When she does it, I think of that all the time. All right, so are you Sadal Wilson? Ma'am, I'm sorry. I was looking at the down
Seidel.
this way and not at you.
Seidel Wilson?
Seidel?
Yes, ma'am.
Okay. And Mr. Rojas, will your client waive the formal reading of the motion?
She will, Your Honor.
Let's see. I'm getting there. All right, Ms. Wilson, in cause number 2240450, I have a first amended motion to revoke your unadjudicated probation. This shows that you were placed on probation February 27th of 2024 for the offense of burglary of a habitation, and that was a 5-year deferred probation. Is that correct?
Yes, Your Honor.
And then it alleges that you violated your probation. Count 1 alleges that you failed to report as directed to the probation department March 14th, March 26th, April 9th, April 23rd, May 8th, and May 22nd, June 4th, and June 18th of 2024. And is that true or not true?
Yes, Your Honor.
Is it true? Okay. Count 2 alleges that you failed to work faithfully at suitable employment and provide verification of that. And is that true or not true?
Yes, Your Honor.
Judge, since we have an agreement.
Listen, hold on.
I'm sorry.
Thank you.
Since we have an agreement, we could drop 3, 4, 5, and 6, and just go to 7, if that's all right with the court.
Count 7 alleges that you were arrested for the offense of failure to identify a fugitive from justice and giving false information April 14th of 2025. And is that true or not true?
True.
Count 8 alleges that you were arrested for possession of drug paraphernalia April 14th of 2025. And is that true or not true?
True.
And then count 9 alleges that you were at a location other than your residence at approximately 12:32 a.m. April 14th of 2025. And is that true or not true?
True.
Did you enter your pleas of true to counts 1, 2, 7, 8, and 9 freely and voluntarily?
True.
Were they volunteer?
Volunteer.
And did you, it's okay.
Yes, Your Honor.
It's all right.
right.
You're good.
Thank you.
Did you enter those pleas of true freely and voluntarily?
Yes.
And did you plead true to those counts because they're actually true?
Yes, Your Honor.
I have here on the computer some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, Your Honor.
And do you fully understand them?
Yes, Your Honor.
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?